This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why the United States District Court is holding fraud in abeyance and why the court restrained healthcare providers' attempts at fraud. Finding that there were illegal financial agreements between healthcare providers, the United States District Court for the Eastern District of New York stayed all attempts by multiple healthcare providers to enforce claims against insurance companies for no-fault injuries allegedly happening and treated by these healthcare providers. The plaintiffs are multiple Geico companies who issue auto insurance in the state of New York, and the defendants were Akiva Imaging Inc., Rush B Diagnostics Imaging, and dozens of other healthcare providers listed as defendants. The defendants contended that the scheme did not reach the size and complexity required by the circuit in various other cases to find serious questions going to the merits and to apply the exceptions to the FAA and AIA. Serious questions exist, according to the court, by virtue of the scheme's complexity. The complaint describes a web of interconnected relationships among the various defendants and illegal financial arrangements, tying many of the defendants together. The allegations of the complaint were that the defendants committed civil violations under the Racketeer Influenced and Corrupt Organizations Act, RICO, common law fraud, unjust enrichment, and aiding and abetting fraud. Geico sought a declaratory judgment that the defendants may not recover on any of the outstanding bills submitted by them. Geico moved for a preliminary injunction to stay all of the defendants' pending no-fault insurance collection, arbitration, and state court collection lawsuits against Geico, pending disposition of Geico's declaratory judgment and RICO claims, and to enjoin the defendants from commencing new no-fault insurance collection, arbitration, or state court collection lawsuits against Geico, pending resolution of this action. The defendants have moved to stay this action pending resolution of the arbitrable claims or alternatively to dismiss it. The court decided that Geico's motion was granted and the defendants' motions were denied. The court found irreparable harm that warrants injunctive relief given the global and intertwined nature of the fraud. The balance of hardships tipped decidedly in Geico's favor, and the injunction is in the public interest because it would prevent fraud and preserve Geico's ability to prove its allegations of a complex, fraudulent scheme involving insurance benefits. The defendants, of course, argued in the alternative that the underlying proceedings do not have potential preclusive effect. Geico misrepresents the rules regulating radiologists and MRI facilities. The scheme is not sufficiently massive to constitute unusual circumstances warranting the sought-after injunction, and the effective vindication exception to the FAA, the Arbitration Act, does not apply here as damages are not clear and definite. The court did not find those arguments persuasive, and therefore the court waived the Rule 65C bond requirement so that the Geico companies did not have to post a bond while litigating the issues. The defendants alternatively asked the court to dismiss Geico's complaint for lack of RICO statutory ripeness, failure to plead fraud with sufficient particularity under Federal Rule of Civil Procedure 9b, and asserting claims already decided by the underlying arbitration and state court suits and thus precluded by res judicata. Again, the court was not persuaded by the defendants, and it concluded that the plaintiff's motion was granted and defendants' motions were denied. The defendants were enjoined from initiating new or proceeding with ongoing collections and arbitrations in state court suits. In my opinion, this is a man bites dog story. Geico as the victim of no-fault insurance fraud by various healthcare providers scheming together to present fraudulent health insurance claims to no-fault insurers like Geico, when in fact the patients were neither injured nor were they treated, just billed. The court stopped the bleeding. The trial will be very interesting, where the victim of a fraud seeks indemnity from the alleged fraudsters. This video was adapted from my blog, Salma on Insurance, which is available free to anyone who clicks on the URL salma.com/blog. You can subscribe to this blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,050 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publications. Thank you for your attention.